If you can make it confusing enough or onerous enough, maybe you'll choose not to carry. And that's really what they want. And so that's what the city of Savannah, it appears that's what they're aiming at. Make life for gun owners as difficult as possible. Maybe the gun owners will go away. We are the Armed Attorneys. Today we're talking about a state sticking it to a city when it comes to a Second Amendment infringement. But before we begin, show your support for the Second Amendment by hitting that like button. And today we're talking about, this is Morris and Firearms Policy Coalition versus the mayor and alderman of the city of Savannah. If you wanted to check this case out, we'll have it linked down below, but it's SPCV 25-00883-KA, and this is in the Superior Court of Chatham County in the state of Georgia. So what is going on?
Well, keep in mind, for those of you who are not aware of the political logistics of Georgia. Georgia is an overwhelmingly Republican state, although you hear about it in the news because of the two Democratic strongholds. As we know, in most of the U.S., the big cities are basically the tail that wags the dog. And here, Atlanta, a major Democratic stronghold. Many people don't realize Savannah, also a major Democratic stronghold. Chatham County almost always votes Democrat for president. So this is not surprising that this sort of law exists in Savannah. And what it is, it stems from it's basically a law where the Savannah City Council recognizes, well, we can't ban guns, but we can put all these kind of onerous consequences on gun owners in case something unfortunately happens to them. And in this case, it would be somebody breaking into an unlocked car. So now, while we all know that breaking into a car, locked or unlocked, is a crime, basically, if you're a victim of that crime and the police somehow determine that your car was unlocked and they stole a gun out of it, then you're the one in trouble. Also, you have to report any gun break-in, any car break-in that stole a gun within 24 hours of it happening. Otherwise,
you wonder why people don't want to go call the police.
Well, I know, and this is completely, like I said, you talk about victim blaming,
right?
And so
that's exactly what this is.
And so what they're saying is that, well, we're not going to catch the guy who actually broke in your car, but if we can somehow blame you for another illegal gun being on the streets, then that's what we're going to do.
Well, and they blame the victim by either, oh, you didn't report it fast enough, or, oh, you reported it, thanks for reporting it. We determined that your car was unlocked, so we're going to hit you with all these penalties. So, yes, this is total victim blaming. And, when we have a criminal intervening, guess what? Blame the criminal. Don't blame the person who was a victim, right? And I'll say, it is good practice. If you have a firearm in your vehicle, keeping your vehicle locked, I think that's keeping the firearm concealed. Yes, those are all very, very good practices. Everybody should engage in that. But where this comes in is with this, and this is where we see the Attorney General for the state of Georgia lining up against the city.
Well, yeah, because Georgia, now you may think to yourself, those of you out there who are, I guess more attuned to what laws are, you may say to yourself, hey, shouldn't there be a state preemption law that prevents local governments from enacting such an onerous burden on a gun owner?
In fact, there is.
There is a Georgia preemption law, and the city of Savannah has thumbed its nose at that preemption law.
Well, and so what is statutory preemption? Statutory preemption is when the state legislature typically takes the authority away from cities, municipalities, or counties, and they say, guess what? We're going to regulate things unilaterally. It's going to be uniform throughout the state, and we're going to regulate it on the state level. That's generally what preemption means. And we see a lot of states have statutory preemption. They say, hey, city, hey, county, we have regulated the wearing and carrying of firearms. You can't touch this stuff. Or we've chosen to not regulate storage. You can't touch this stuff. And it appears that Georgia has done this.
Right. And preemption laws are important whenever it comes to firearms, because this is not like allowing cities to have their own laws whenever it comes to what kind of bag your garbage can be in, or how, big your hedges can be, or how long your grass can be. This is something that affects people who live both inside and outside of Savannah. And so you cannot have this patchwork where somebody who lives outside of Savannah but happens to do business or employment in Savannah and says, well, look, I got to go to 3 places today Two of them are outside Savannah. One of them is inside Savannah. Now, somehow, I am prevented from carrying my gun with me to protect myself in my car because I happen to be going into Savannah and perhaps my car gets broken into, and now I'm subject to all these regulations.
And it's really, I mean, I'll say it's nice as a practitioner when I have someone who calls me and says, hey, I'm driving from Houston to San Antonio or San Antonio to Dallas. What are the gun laws there? And I can, confidently say the gun laws are uniform throughout the state. Carry the same way you do in your hometown. That's very helpful for gun owners because this is the gun grabber strategy. If you can make it confusing enough or onerous enough, maybe you'll choose not to carry. And that's really what they want. And so that's what the city of Savannah, it appears that's what they're aiming at. Make life for gun owners as difficult as possible. Maybe the gun owners will go away.
And therefore, yes, they'll be discouraged from going in place. Now, one of the things that you also have to realize is that, and this is where a lot of people don't understand when they talk about prohibited places, is they don't understand that having a prohibited place then has all of these necessary consequences that flow from it. Because one of the reasons that somebody may leave their gun in the car is because they can't take it into the place they're going because it's now a prohibited place. And so, they leave in their car gets broken into. Maybe they were just passing through town.
Way to go, nanny government. You made a big, instead of having getting rid of gun-free zones, now folks are getting their firearms stolen out of their cars.
Right. And so, if this happens, like I said, you have all of these, the police will investigate as to whether or not you left your dog, whether or not you left your car unlocked. I have no idea how they intend to enforce that.
I don't know how you lock a dog.
Is anybody going to say, I left my car unlocked? Who would say that?
Well, the police are going to say, oh, we don't see any smashed windows here.
Well, then that's why before you call the police, you just knock it out yourself.
Sure. Don't tamper or fabricate with evidence. So now this lawsuit actually got originally filed back in 2024, but it was dismissed because the person actually wasn't a resident of Savannah. But like you said, folks can travel into Savannah, and if it's going to affect them, you would think they would have standing, whatever.
That seemed like a really
mealy-mouthed way of getting out of it.
Correct.
But now we have a new lawsuit, Deacon Morris Firearms Policy Coalition. This case, and this is kind of what brought it to our attention, the Attorney General for the state of Georgia, A.G. Carr, he filed an amicus in support of Firearms Policy Coalition and these folks. So it's pretty interesting when you see state go up against city, especially where their preemption seems pretty clear-cut. I just wanted to read this because it says, no county or municipal corporation shall regulate in any manner the transportation, carrying, or possession of firearms by license holders. So this one specific to license holders. Maybe Savannah's ordinance might be talking about non-license holders. That just seems like a impractical application.
Right. And if they're going to argue, hey, this only covers transportation, carrying, and possession, it doesn't carry storage, we're talking about storage here, then it'd be very interesting to see how they would justify them prosecuting somebody whenever they would not have the element, they would not have the mens rea of, hey, I was not in possession. How can you penalize me for something that I had no control over?
Yeah, but we're going to be watching this case. This is one of those interesting battles that, really, even though this is in Georgia, seeing how statutory preemption shakes out is very, very important. A lot of states have this stuff. A lot of states don't. Some laws have teeth. Some states don't. I'll say Georgia's law does not, in my opinion, have enough teeth to it because the damages are actual damages or $100, whatever is greater, reasonable attorney's fees. So
that seems a little antiquated.
Yeah, it seems a little antiquated. They probably need to bump those numbers up. Those are rookie numbers, and I'll say Texas is, as far as teeth goes, we delegate our authority to the Attorney General to file these suits, and if he's just not interested in filing, taking it to court, does our law really have teeth? So we are following these things. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to question and comment in the section down below. And until next time, we're the Armed Attorneys.